Welcome, everybody. Thank you for taking the time to learn a little bit about why your young adult child, or maybe upcoming adult child, might need some elements of an estate plan. I look forward to talking to you today about a couple different topics, but first and foremost, I just wanted to do two quick things. The first is, of course, to say that I wouldn't be a good lawyer if I didn't make mention that this does not constitute an attorney-client relationship just by nature of watching this video. We do hope that you'll be our client someday and you're welcome to reach out to us, but our firm is located in Phoenix, Arizona. I can serve clients, or we can serve clients throughout the state. And just a little bit about myself personally, I'm Emily Taylor, and I grew up in the Midwest, but it's been about 26 years since I left, and I came here to go to ASU, went down to Tucson to U of A for law school. And since that time, I've been practicing in the area of estate planning and adjacent fields like probate and special needs planning. Proud member of the Special Needs Alliance and the National Academy of Elder Law Attorneys. And happy to answer any questions, but you can learn more about the firm at our website. So I'd encourage you to go check out emilytaylorlaw.com. Today, our goal is at a high level to kind of look at some of the elements of an estate plan and talk about why they might be important or critical for your young adult. So if you're watching this as a parent, learning more about what should be taking place for your young adult children, this will be covered. We're going to talk about what happens when you turn 18, some of our medical and education elements of decision making, and then financial, as well as wills and next steps. So the reality is that I presume if you're watching this, you've probably turned 18. And if you're anything like me, probably remember saying, oh gosh, I'm not an adult. And now when I look back at who I was and I look at other 18-year-olds, it is sometimes shocking that they're allowed to make decisions, that we allow them to contract, we allow them to make their own doctor's appointments, let alone, do some things that are probably what we would call scandalous, buy cigarettes or lottery tickets or whatever that looks like. But the reality is there's an imaginary threshold. We go to bed one night and we're 17 and we wake up the next day and at some point we turn 18 and now all of a sudden we hold all this power and our decisions have real consequences. And so in my practice, I work with a lot of families where we have young adults who perhaps don't have the ability to make their own decisions, and that's kind of a different conversation. But today we're focusing on young adults who are able to make their own decisions, good, bad, and ugly, and what we might put in place for them as either they head off to school, carry on, maybe they're a young senior. Some people start their jobs or trades or take a gap year or head straight to work. But what's important at that stage and what it really changes. So everything changes. You might have 18 years of experience of making pediatrician appointments for them, and suddenly you call a week after their birthday to follow up on that appointment or that prescription the doctor was going to call in, and suddenly we find out you can't talk to them or they can't talk to you. You might also find out that you're getting kicked out of the pediatrician office, that your young adult now needs to go find their own primary care. You for sure can't make decisions on their behalf, so you wouldn't be able to respond if there was an emergency and make decisions. You can't go access their bank accounts. And if they're off to higher education or frankly even high school, there are some education pieces that you won't be able to access grades. You won't be able to look at loans and student financing, things like that. In essence, the law says your job as a parent has ended. The reality says probably not. So the first thing we want to cover is health. This tends to be a big one because we do have, sports physicals, annual physicals, let alone having any sort of health decision making related to maybe a chronic illness or a disease. And of course, there's emergency medical decision making. So HIPAA is going to govern our ability to access information and talk to medical providers. So HIPAA stands for the Health Insurance Portability and Accountability Act. It is the law that says doctors' offices can't communicate about a person's private health information, and they can't provide medical records. That extends to other healthcare providers. And it's important because we want to authorize this, but it's not necessarily a given that you'll be able to get the information you need. And so in a situation where perhaps your child goes off to school and then is hospitalized after a car accident, you call the hospital looking for an update, trying to figure out where they're at, things like that. They may be restricted by HIPAA from telling you or giving you this information, even if 6 months ago this was your child and you were making all these decisions for them. Now, on the other hand, what we want to look at is there a tool or a mechanism that we can put in place to allow for that to continue to be something that we can have use of? And so generally there are HIPAA authorizations. There are broad ones. And if you've done your own estate plan, you probably have one of these documents in your plan, but we want to make sure our 18-year-old also has one if they're comfortable with you being able to continue to talk to medical providers, get information from insurance companies, make appointments, things like that. And so we want to make sure we're really clear about who has that authority, and if our young adult is willing to, making sure that they sign a HIPAA waiver that's broad, not to just a specific medical practice or doctor. From HIPAA, we also want to start to look broadly at tools called powers of attorney. So powers of attorney are going to be legal documents that I believe, frankly, everybody over 18 who can sign them and can put them in place should have them. And they can be both finance and healthcare. Today, we're going to start talking first about the financial power of attorney. Now, we hear different terms, but we hear durable, durable financial, property, general power of attorney. There's a whole lot of language that can apply to the same tool. And that tool is a written document that allows the principal, the person signing it, to grant authority to their agent or agents under certain circumstances. Now, in this context, we're talking primarily about financial authority. And so when I think about my own financial power of attorney, I have a document that lives in my estate plan that says, if I'm incapacitated, here is who would have authority to come in and make financial decisions for me. In thinking through who my team should be, we want people to think about who is trustworthy, of course, who has the capacity to take it on. If we're thinking about your young adult, we're thinking, well, hopefully they're going to name mom and dad. Or if there is a blended family or a modern family dynamic to that, responsible adults of their choosing who would be able to handle financial decisions. Now, the agency granted under a power of attorney for finance is typically one of two things. That is, it is typically either effective upon signature or effective immediately. That means when the young adult signs the documents, then if they've granted you as an agent, you can then use that tool to go continue to do some of the financial things you might have been doing, getting access to bank accounts, making decisions about student loans perhaps, and you have the authority. Alternatively, the financial power of attorney could also be springing, meaning the power of attorney is in place, naming or nominating agents to act, but it doesn't carry any authority or it isn't allowed to be used until such time as a certain criteria is met. Now, for incapacity, most of that time you're going to see either a doctor needs to make a statement in writing that you've lost the ability to manage your financial affairs. Some power of attorneys will require more than one doctor. I have different feelings about that, but all I know is sometimes it's hard to get several medical professionals to agree in writing to one thing. So we want to be clear about what it says if that's the case. But for our young adult, generally, if there's a good, healthy relationship, and unfortunately, sometimes that means they're primarily benefiting from your financial resources, we want this young adult financial power of attorney to be effective immediately. So perhaps they're moving across the country to go to school or start a new job, and they have a lot of their banking or financial set up here in Arizona, and it would be helpful for you to perhaps have access to those accounts, of course, so you could deposit a check or some cash into their account from time to time. But on another hand, it may be more appropriate just to say, we're going to have this document or this authority in place in case of emergency. We want to make sure it survives in capacity. And so we're going to have this financial power of attorney that's springing. And again, would only come into play if there were an accident, injury, or illness that led to your young adult's inability to make financial decisions. The good news is about all of these tools is they're revocable. They're going to change over the years. For better or worse, your young adult may fall in love. They might have their own children. They might make good friends and have professional advisors, and life moves on. And so chances are this first plan where they nominate their parents is probably temporary to a certain extent. But it is critical because, again, once they're 18, we want to make sure that, again, in the event of a catastrophic injury or illness, or frankly, even a temporary setback, that they've granted the authority we need, allowing for these decisions to make these decisions to be in place. So oftentimes we'll have a primary agent, a primary decision maker, but we also want to have a backup or two. And of course, we can have co-agents as well, but we need to make sure they can work together. Most financial institutions will require that any co-agent arrangement needs to indicate that they have independent authority to act. And again, that's just typically for life limited liability exposure. So sometimes you'll find a financial power of attorney that is very specific to a certain task. Sometimes you'll want one that's more broad. And generally, I think the broad financial powers of attorney are helpful tools that allow us to cover things that we don't know if they'll come up or if they won't. And we want to know, make sure that we can avoid conservatorship. So the nice part about having a financial power of attorney is in that worst case scenario, we're not faced with going to court to get the authority we need. And so if our goal is to avoid court in this context of financial decision making at incapacity, what we're trying to avoid is a conservatorship. So in Arizona, conservatorship is when an individual is incapacitated. The court makes a finding of that. They remove that person's rights to make decisions or contract, and they give it to the conservator. That's a stressful process. It's complicated, and then the court's going to oversee the length of the conservatorship. So it tends to be expensive and slow. And so if we have people in team that we trust, we want to put this document in place to bypass some of that. Now we move on to healthcare. Healthcare powers of attorney are really important as well. And similar to a financial power of attorney, they're going to be in place when a person can't make or communicate their own decision. That could be a very short period of time when they're under anesthesia, or it could be a longer term injury or illness. We want to make sure that healthcare agents are people who would be responsible for advocating for our desires, right? So your young adult probably feels strongly about some things. And of course, it's important that they nominate people who feel the same way. And so again, it's commonly parents, especially if the parents can still co-parent together in that way, then they can co-agent in that way. But if not, we want to be clear about who does have that authority, because under the law, if a young adult is not married, doesn't have adult children, and is injured or ill, and we have to go through that process of conservatorship in finance or guardianship in healthcare, the parents have equal priority. And so that can get really messy in families where there's been a divorce or there's not a long-standing relationship. And so just being really clear about who that is and allowing that child to make those decisions. So these documents in healthcare are going to be specific to who can advocate in a hospital setting, who can be clear about managing prescriptions, who potentially would decide if you can't live safely at home, where you should live. So this might be a different lineup than finance. I know, for example, I have two adult brothers. One might be great at healthcare advocacy, really understand my personal beliefs and philosophies and be able to advocate for me in that setting. But maybe not so good on the financial side, and hopefully my other brother would be able to handle that. But your young adult's going to think through the same thing. Now, typically it is the parent, but they get to choose. So they can choose to name a friend or a sibling or another adult that's trustworthy in their life. But this, again, activates when they're unable to make or communicate their own decisions. Now, one of the unique things about Arizona is not only do we have the healthcare power of attorney, we also use documents called living wills or advanced healthcare directives. And you're going to see different ways of addressing certain questions. So in Arizona, I would say most commonly in your healthcare power of attorney, we're actually addressing organ donation, autopsy, and burial. Living wills, you sometimes see those decisions conveyed in that as well. Sometimes you see them combined into one document, but a living will is going to be allowed and encouraged to be able to indicate what a person's wishes are if they're unable to communicate on their own, but related to end of life care or advanced medical treatment. And so many of you watching probably remember the young woman, Terry Schiavo, who had uh, health crisis, a cardiac event that left her in a vegetative state, and family members were fighting over whether or not to keep her alive. These may seem like very serious and big topics for a young adult to address, but it is critical. And it's so interesting to me when I meet with young adults to go through these. Oftentimes they have pretty strong feelings, and some of that's driven by perhaps watching you as their parent make decisions for your parents. Sometimes it's driven by the media they're consuming. If they're, fans of The Pit or some medical drama like that we see on TV, Grey's Anatomy or the like, they might have strong feelings, and it might be interesting to have that conversation and to learn what they think about. But again, just understanding what level of care, what level of treatment, and advocating for that, and always understanding that they can update those as time goes on. Now, I'm not pledging allegiance to U of A, so if you recognize the Old Main on there, that was just an easily accessible document. I also, of course, went to ASU, and I could put Northern Arizona up there as well. But one of the other things that happens is if your young adult is going to higher education, sometimes there's reason for you to continue to have access to not financial, but to education records. And so FERPA is our law that allows for the Family Educational Rights and Privacy Act. And it's something that once we know where they're going to be going to school, we want to investigate what documentation needs to be in place so parents can access records if that's appropriate. Now, sometimes that's important because they're still over the age of 18, but still in high school. But sometimes it's really critical for continuing education as well because it might have to do with financing through student loans or school work, that kind of thing. And especially if something came up, where perhaps our young adult was not attending school in the way we thought, or we wanted to learn more about enrollment status, it can be a helpful tool. So a FERPA waiver, like a HIPAA waiver, if we think about all the acronyms, is going to, upon signature, allow certain people to get access to those records, and that can be really critical as well. So with that, those are some of the more important or priority documents. I do also want to spend a minute talking about wills and beneficiaries. And this is because, a lot of times we imagine a little old lady signing her will and it's the end of life, and that's all we need to think about as people who are elderly. But the reality is that young adults today sometimes have assets or resources that need planning for as well. We'll see a young adult who is really good with science and might have some intellectual property or might have some electronics that are valuable, digital assets. Also, they might have bank accounts, or perhaps they have funds that were given to them or set up for them, both for education or personal, and they might have inheritances as well as, things they save for. So vehicles, personal property, then over time, those assets can accumulate some value. So it's not something that necessarily needs to be documented for everyone, but it is a good reminder that it's something we want to consider. We also want to understand if there's not a will in place, if there's not a legal document that says who would inherit, what is the default? What is the state's plan for those assets? Because again, not every family matches our statutory law. And so if the law says that if you're a young adult and you pass away and you're unmarried and don't have any children, that your assets are going to go to your parents, yet one of your parents has been estranged your whole life, or perhaps you were raised by a step parent, we want to make sure that that matches the intentions And we also want to consider potentially avoiding any court headaches or things. And so we want to look to beneficiary designations as well. Now, one caveat I'll also put on this, given our practice area, we work with a lot of families who have siblings who maybe can't have or receive inheritance. And so it may seem surprising that I'm encouraging a 23-year-old to have a will or a unique beneficiary designation. But if that 23-year-old's closest relative is a disabled adult sibling and or minor sibling, and by nature of some terrible accident or surprise, they leave an inheritance to their sibling, that's going to be really problematic for their government benefits. So things like understanding and just keeping up with what assets they have, who they're naming as beneficiaries, allowing them some room there, but providing education that if they've got a close relative who may be negatively impacted by the receipt of inheritance, making sure we're really clear and critical about what that looks like. And so again, we see, different types of accounts that people have, investment accounts. Some young adults might, have a Robinhood account, for example, where they buy and sell stock online and maybe they strike it early, or maybe they're diligent about just putting away their savings. We want to know and understand who their beneficiary is and that they've been intentional about it. So a lot of times this is a lot of adult education that can be helpful. Doesn't mean they need a full fancy trust-based estate plan, but just really, again, going back to what do they have, who are their beneficiaries, or how are things owned, and who would inherit if they had a lapse in that, and would that be problematic? So, we've talked a little bit about what these different elements are and why they're important, but again, to focus on what happens without these. If there were a medical emergency, parents are turned away at the hospital because of lack of HIPAA authority. They wouldn't be able to make or communicate decisions on their behalf under certain circumstances. And in that case, they'd have to ask the court to make a finding of incapacity to be appointed as legal guardians. That can take a long time. It can be very expensive, and it can definitely feel very stressful when there's already a very stressful circumstance going on. Financial crisis abroad, you might imagine, your son or daughter goes to school and they decide to study abroad in their junior year, and they're overseas and their wallet gets stolen or their passport goes missing, and now all of a sudden they're calling you asking for help, but you don't have the tools to be able to communicate with the financial institutions. Again, it's a mess. And so we want to have some of that documentation in place if that's appropriate. Legal dispute. So if there's a car accident, if there is some sort of contract dispute, you're not able to step in, you're not able to participate, things like that. You might not be able to talk to their legal representation. Again, things to consider, risks that are in place. And then, of course, an academic crisis. We worry with young adults sometimes about mental health. And so with that, especially with some psychiatric conditions, we can see an uptick in behaviors and cycles that take place, after they're adults, but lead to a change in their education, a change in their mental health care, and having those important critical documents in place, allowing that mental health care power of attorney to be used is really, really important, so that, again, we're not going through a court order treatment process or a guardianship with mental health authority as well. So here's a quick checklist. You can see up here, I believe personally that a financial durable power of attorney with a healthcare and HIPAA is essential for everybody. And frankly, I might throw that mental health care one in there as well. But I also recommend, again, a living will is a great conversation starter with your young adult to understand how they feel and how they see the world and what that looks like, and to provide them education. It might also be a good two-way conversation, so you can start to introduce them about what you believe and what you would want, so that someday when they're in a position to make decisions for you, they have a better sense of that. FERPA, if they're in higher education, making sure that access to education records is critical. Wills, again, depending on what they have and who the default is, might be a helpful tool, and beneficiary designations. So hopefully just going through those things, quickly with them, whether they're just heading out or perhaps they're boomeranged back into the home and now you've got a 24 or 25-year-old living with you again. Just kind of going through these young adult documents, and this checklist is critical. Our firm is happy to help, so we'd be happy to meet with your young adult to talk to them about what their goals are and be transparent on what they might need based on their circumstances. You're welcome to schedule an appointment through our website for an intake, and then we'll get you set up to get that meeting happened. Now, of course, when they're 18, they're our client, so they get to make decisions. They get to have private meetings. You don't get to control that, but it is something that you might help them coordinate. Both myself and Mary are the licensed attorneys in their office, and we're happy to focus in this area and meet with them and talk to them about that. And we both happen to have stepchildren who are young adults, so lots of learned experience and some recognition of some of the things that come up for them. And I think it just for you, you've probably put a lot of time and intention into your own estate plan. And so having this in place can also be peace of mind that you've got it both directions, that they also have that authority. So a couple questions that come up quite a bit is, if your child's healthy, do we need this now? I hope not, but of course that's not why we're doing this. It is helpful if they're 18 to have it now because we need them to be put in place before they're needed. It's too late if something happens. Um, can we just use online forms? Absolutely. So Arizona, that says sometimes in the answer, but I'll say absolutely. I'd prefer something is better than nothing. Arizona does have free health directive registry, health directive forms through our attorney general. Those are a great place to start, but do always make sure that if you're using forms from online, that they match Arizona laws, because from state to state they vary, and we just want to be clear that we're meeting the right witness and notary requirements and that they'll be recognized by our local institutions. Now, if your child goes to school out of state, but Arizona is their home base, then we definitely want to make sure that their documents are compliant here in Arizona, and typically they're going to be recognized throughout the United States. If they're studying abroad, there might be a conversation about what that looks like. But again, if it's a temporary thing, then we'll want to update that. And these documents for them, it's just their very first version of an estate plan. And so I tell almost everybody I meet with that I hope this is your first or your not your last estate plan, right? That means we're going to live or have opportunity to change things as life changes over the years. So I definitely anticipate that these tools will be in place until they fall in love, move to another state of their own, become a professional, and hire their own attorney. But yes, I definitely we want to make sure they get updated. They should probably be updated along with major milestones. So tends to be as a young adult, we see those big milestones coming when we marry, have young babies. That's a big time to look more closely, or have a significant change in assets. And so if they start earning more significant income, they buy a house, those kind of things. And typical cost is, a couple $100, I would say. It's not going to be thousands of dollars like a trust-based plan or other types of more critical planning, but depending on the level of complexity, we're happy to tell you that up front. So just give us a call or schedule an appointment and we'll look at that. Um, and, overall, the takeaways can't be overemphasized that parents lose legal authority when they turn 18. There's a lot of rules in place, both at the federal and state level, that make it difficult for parents to be able to continue to participate in decision making. And so, at the minimum, we want to make sure we've got some healthcare directives, some financial powers of attorney in place, and we understand what else might be needed. And the documents are pretty easy and affordable and provide an more enormous sense of relief that if the worst case happens, that you've got the tools that allow you to continue to be the important decision makers in their life. Um, and so I'll just say thank you for that. And I'll offer those of you who are online to ask questions. I've got one here that I'll do in a second, but I will also just ask, if you need anything, please feel free to reach out to us. We're happy to work with you. We've got a great team. This picture is only a couple of our team members, but we're happy to talk to you through this process and answer any other questions for yourself. So with that, I'll say thank you.